Hi, everyone. Again, welcome. Thank you for being here. Our third of 5 series webinar on agritourism. We hope you've been enjoying it so far. I think Anne has been hitting it out of the park. Tonight, we have Andrew Brannon. I am so confident that Andrew is going to be able to follow Anne's strong past 2 weeks. Andrew is a professor in the Ag and Natural Resources Department at NC State. Everybody's got their camera off, but if you want to do this behind the camera, that's fine. That's fine. He is a lawyer who concentrates in agriculture, real property, environmental and natural resource law, and he focuses on real property and farm succession. I have known Andrew throughout his career. I have heard him speak many times. It is always very interesting. I always learn so very much. He's going to tell you a little bit about his background as we go through the presentation. So I'm just doing a short and sweet intro. But Andrew, we are so excited you're here to talk about this very important topic.
Well, thanks, Carol. Hey, everybody. And I really appreciate the Uplift team for inviting me to do this. This is a topic that at NC State Extension, we've been, I will say we, because I've sort of been part of the development of curricula around agritourism in general, business development, and things like that. And my focus has generally been on the liability side. And how I thought I might approach this tonight is to first show y'all where, for information, just really on farm law, land use law, things like that. This is the web portal that Cooperative Extension IT was kind enough to set me up with. This is just Google farm law in CSU and it'll pop up. And I've got, just this website here is really the expression of my existence at NC State. I mean, in terms of the extension world. I post up articles, post up all the presentations, the 3 presentations that I have open right now to try to address questions and provide general information they're all on this website. And so you can just navigate around. As Carol said, I've my past experience in private practice. I did a lot of farm succession, did a lot of different land use issues and such. But you can go in here, and I'm just pulling up one for fun. There's articles on all sorts of topics, and then presentations, and I try to keep things pretty current to my current thinking on various topics, because it does tend to change from time to time. We got a couple of handbooks for those of y'all in the world of owning land with siblings, looking at your own future and farm succession planning, things like that. And then folks on the beginning end, this is a workbook that Carol had referenced earlier, that I was involved in putting together a number of years back. But so all that stuff's on the website. And so tonight, and I guess I should say that my background in this, if I can establish any credibility with y'all, I've been in the ag space as a lawyer for about 22 years now, working in the nonprofit arena. I had a decade there in private practice, and then I transitioned from private practice over to North Carolina State to teach ag law and teach environmental law and do this, teach out in the counties. Just law on a lot of different topics. And so it's funny, Carol called me a lawyer. I refer to myself now as a legal educator. So I know I never really wore it that well, but I've learned a lot along the way, I think. And so tonight, the general topic on the table, as we look at agritourism from a legal perspective, is going to be in the realm of risk management. And when I use the term risk management, I'm saying generally, how do you protect your assets from something going wrong when you invite somebody onto your land? a couple of questions came in, were sent to me beforehand. I know there's a question on the table about premises monitoring and liability for trespasser injury, and some on insurance. And if you got questions, you could keep them flowing in through the chat portal or the Q&A thing, that'd be great, because I'll just stop and try to address them. And so I think the best way to start, if we can follow a particular narrative, and I hope it's okay that I keep it in this mode here, rather, so I can see what's coming next. And so there's what's normally there. And so I'll talk about liability versus the concept of regulation. So I get a lot of questions all the time about, what does it mean to be a farm? What do I have to be officially a farm? That's somewhat, it is a topic, and it's a different one. But I'll reference, regulations such as they are in the farming space, and how that relates to liability. Talk a little bit about liability insurance, and then if we have time, and I keep my wits about me, we can get to talking a little bit about business entities. But I'm not certain we'll get there. So when we talk about liability versus regulation, liability is the English common law concept of your responsibility for somebody that's injured. It's a concept that has developed over the course of 600 plus years. We have adapted it here on our continent to the differences between us and England, but it concerns a relationship directly between you and a person that's injured. When we talk about regulations have developed over the course of not quite as long, but really the past century and a half or so, where we, the people, are empowering our government, and usually local government, to protect us, to us protecting ourselves. And regulations are informed by tort law. A lot of bad things happen over the course of years. People get hurt, things like riding on trains and doing things like that. And so we start developing regulations to prohibit activities. And that's how our body of regulatory law starts to develop over time. They are related in the sense of, there's a better slide for that, that if you find that you are subject to a regulation, and in farming, there's a lot of exemptions from regulations that would normally apply to other businesses, things like licensing, zoning, things like that. But that if you are found to have, in some sort of context, and the context I put it in normally is when you're out on the highway with a tractor, and let's say you're not keeping the trailer or the tractor, whatnot, properly lit, you're now outside of compliance with the regulation. That does have an impact on the burden of proof that the person that gets injured running into the back of you will have to bring forth in order to hold you liable before a jury. Another example of that is going to be loose livestock out on the highway. I've gotten questions for years about our North Carolina fence law. It's really just a statute that's one sentence, and it says if you have livestock, you must keep them fenced. And I've studied a lot of cases on what happens when livestock get loose, and people run into a Black Angus cow at dusk out on the highway. It happens all the time. And so if you don't keep them properly fenced, or something to that extent, that could also impact how the job that the plaintiff will do in terms of assigning liability to you. But the first thing, and let me get away from all that. Yeah, that's an example I used. Again, all of this detail is housed in these presentations. Jumping quickly to insurance. So I look at how not to be found liable in three echelons, so to speak. The first is just operate in a safe manner. If there are regulations, food safety regulations, things like that, follow those. If the second line of defense is going to be insurance. And I get a lot of questions about, when should I have insurance? What type of insurance? I'll jump to that, talk a little bit in detail about that. But in my experience, insurance is largely dictated For farm operators, let's say you're producing product and you're selling it off the farm, which is or selling it, which is really legally what qualifies an operation as a farm in North Carolina. It's going to be dictated by who you're selling to. And I put some examples here that if you're selling, I use Weaver Street Market, which I live over in Chapel Hill, Carborough, and that's our local food co-op. If you work with them, you provide produce to them, they're generally going to require that you have a liability policy. If you are, Walmart has one too. Yeah, okay, actually I found it's in the next slide. Just as an example, you would find this if you're doing business with certain vendors, and their requirements for the liability policies you must carry. And you can see this, if you want to sell produce to Walmart, you got to carry a lot of different types of insurance. You got to carry workers' comp, you got to have a product liability, you got to have a commercial general liability. And what this is hinting to is that there are lots of different types of insurance. Generally for agritourism operations, your basic policy is going to be what I refer to as the premises liability policy. And it's going to be something that's fairly basic for somebody is on your land and they get injured and they have a potential claim against you. And so the benefit of insurance is that in this, we were talking earlier about an operation who is having some trouble getting insurance for their entertainment thing that they had going on. And if you don't have insurance and someone gets hurt, then you're left to deal with it out of pocket, because one of the big benefits of insurance is the contract between you and the insurance company carries what's called a duty to defend. And so it will be the insurance company, when something happens, that calls up a law firm that just does these cases, or just an insurance defense firm, and they'll take over the case and deal with it. And of course, if there is a verdict, then the insurance policy will pay that. Generally, verdicts, I will say this, are rare, because most accidents, y'all probably know, are settled. They are settled after litigation is filed. Generally, I don't think insurance companies, will take a potential litigant seriously until they actually take the step of going and finding a plaintiff's lawyer and filing a lawsuit. And at that point, that's when the case is engaged, and they'll do their math and consult their algorithms and such, and decide, is it worth it to go ahead and pay this off, or take it all the way. So insurance generally, I guess I'm just going to go ahead and address insurance now. Talked about the duty to defend. The challenge with insurance and agritourism, and I told just all farm operations this, because so many farm operations, particularly as they've moved from a traditional row crop in the previous generation operation to something where that's more agritourism focused, because you find that there's less land to expand to. You have a smaller footprint in the community. You have to be relatively near an urban area. That this agritourism tends to be a vertical income model on a more limited land footprint. So when that transition happens, when you make the decision to, instead of just growing strawberries and taking them to the farmer's market, selling them, I'm going to start inviting people onto my land. And at that point, the person coming onto your land is known as an invitee. Invitees have, I'll get to the trespasser versus invitee, but your general obligation is not to keep them absolutely safe, but to not be negligent in allowing an injury to occur. And we can, I guess, go into some examples of what that might be. But what I always tell operations, when you are changing things, and as you're out shopping for insurance, and you're talking to insurance companies about the types of policies that you need, or if it's just one policy, I suggest to folks that they have a good, sketch of their business plan, that they can present to the insurance agent, who is, the underwriters will evaluate, what the risk is and decide to insure and what the premium is going to be. but they need to know. And when you make a transition from a regular, just a commodity operation where people aren't coming onto your land, to a situation where people are coming onto your land, the insurance company's got to know, because you might find in there in the language of that contract, that the insurance company, when an injury occurs, they'll look at it and they'll say, well, this is not something this policy covers. And so I always tell my students, in law, there is no such thing as it's better to ask forgiveness than permission. It's just not a thing. When a liability, or when a potential liability occurs, when an accident occurs, you can't put things back in the bottle, so to speak. And then you're sort of out there in the wind, hoping that your insurance policy is going to cover you. Different types of insurance while we're on this route. You can see I feel like I'm just scratching the surface, because I've never worked for an insurance company, so I don't really know how all these policies can be sliced and diced and combined and all of that. The insurance companies know that. What's important is you're explaining to them what it is you're doing on the farm, because they'll want to know, what types of activities, my assumption would be they'd like to see pictures of what's going on, to evaluate, the risk of somebody getting hurt. And so that's a conversation that occurs between you and an insurance company. So this chat thing's going to keep lighting up, and I'm going to pause in just a sec. Insurance policies cover what they say they cover. I'm not endorsing Farm Bureau, fine organization, but I just pulled this off of their insurance company site. I just screen captured and pasted it, without permission. But you can see they, have all sorts of different types of policies, that are going to cost different amounts and cover different things. Your basic farm owner policy, and again, this is the standard policy. If you just own a farm, you own a parcel of land, and you want to have insurance in case somebody comes on the land and gets hurt, and you need to defend it or defend that potential lawsuit. There's a basic farm owner policy which covers just different things. But you see here, I have this. There's a list of exclusions on there. That's going down into the weeds literally, but business pursuits. It says farming, but again, farming can be a bit subjective. And in North Carolina policy, our policymakers have wrestled with what that definition is, particularly at the local level. And if we get to it tonight, we can talk about the bona fide farm and all that kind of thing. But one of the here again, I'm saying that insurance policy covers what it says it covers. And so you don't want to be in a situation where you're reading the language. And I'll just put an example up. I screen captured these from this ISO policy. You don't want to have it left up to you to interpret what these words mean. You want to basically, to my mind, have it in writing from the insurance company that their understanding of what it is you're doing on that farm. What this is here, and it's very, very important, then when there is an occurrence, when something happens, this is an obligation of you as the insured to, you see here, I circled that. So it's duties in the event of occurrence, offense, claim, or suit. And you must see to it that we are notified as soon as practicable after an occurrence. And that doesn't mean after a lawsuit's filed. It doesn't mean necessarily, I don't know this, but it may not mean even after you're contacted by the child's parents of, hey, here's our hospital bill. I think when somebody's hurt, that it's best practice to go ahead and alert the insurance company. And I would say any concerns over, again, I don't believe that that's a grounds for them dropping you. They're not relieved from their obligations under their contract because something's happened. That's why the contract exists. It might be later after something happens that they're like, yeah, this is too risky for us going forward, so we might not renew this contract. But that's for another day. Your obligation is to let them know, as soon as practicable, literally says here, after something happens. Um, so I want to see how fast I can move along so I can talk about um, uh, coverage of farming. Again, these are just some general terms you might find in policies. I've just talked about your obligations, and again, these are outlined in the statute, or I mean, in the policy. So this is a feature of North Carolina law, and as agritourism has become an accepted business model across the country, most states, and I think maybe all, have this type of law. And in North Carolina, this one was passed, I want to say around 2010 or 2011. I don't quite remember, but I was cognizant of law and farming at the time it happened. I might have been in private practice, might have been working as a nonprofit. But this law was crafted and put in section 99E of the general statutes. And I have what it generally says is that if if there's an injury on a farm, that the farm's not going to be liable. Now, it's not saying that necessarily, because it doesn't cover you if you're negligent, if you have fallen below the standard of what a jury might think a reasonable person in your situation would have done to not allow that injury to occur. What this statute is, though, it's a mechanism by which um, your insurance defense lawyer can move for a dismissal of the case. And again, it's up to a judge. A judge could choose to ignore this law um, and the case proceed forward, but it gives the judge an out, so to speak. It provides some cover to where they can look at the case and they can dismiss the case. We have very little research on this. There are no cases in North Carolina to tell us how this law actually works. But just the what it's there for is to try as a favorable farming public policy to get these types of cases dismissed. And the principle in law that it operates on is called assumption of the risk. And so it's very much like a liability waiver that somebody would sign when they came onto your farm. Because what it's saying, you can read the language here, the warning under North Carolina law, and it says no liability for injury or death, an agritourism activity, and it says resulting from inherent risks. And it gives us a little bit of a list. Activities include inherent to land, equipment, animals, potential for you to act in a negligent manner, meaning you're the one that goes up and gets into the bull's pasture and goes up and tries to pet it. But we don't know really how these, what facts are at a trial of this make inherent risks give it more color, give it more illustration. And so what this is for is to provide a potential way that a lawsuit can be dismissed. But there's a catch. The statute itself requires that you have posted 2 signs with this exact language. And I know from cases or researching cases in other states where there have been reported appeals of these matters, that if the plaintiff's lawyer says, well, we don't know that those signs were there, my client didn't see them, the judge might turn to the lawyer for your operation and say, can you provide evidence that these signs were posted? And so I tell everybody, post one out at your gate, take a picture of that, post one at really the point of sale where you interact with people's money, and more if you want, but 2's the minimum. And so NCDA, the Agritourism Network Association, or whoever does the coordination over there now, they sell these signs. You can print them yourself, but it's good to have them on something that won't rot in the weather. Let's see what else. Let's not do the workers' comp stuff. Let's move over to. I want to show you generally what these signs look like. And if you're in agritourism now, I'm sure you already know this. The 99E statute doesn't just protect farming, it protects there's one a, um, a section for roller rinks, for other types of, I'm forgetting which other types of dangerous activities. But you can see here, this one is this one's the agritourism one. The first one, I think, was either this one, which was for people who are doing livestock demonstrations on the farm, on their parcel of land, to provide them this cover that animals behave in erratic ways, and if one bolts into the stands, hey, that's just inherent risk. And equine got one too, and the equine liability statute has a lot of useful detail in there about providing faulty tack and things like that. So yeah, this is sort of where I've jumped over to, and I'm illustrating what are inherent risks for somebody visiting your farm. I've just thrown in some things I made up. Salmonella from petting goats. Foodborne illness from goods sold on farm, it's a product liability thing, but falling off a hayride, different types of things. And we don't really know. There was a case in, I think it was Tennessee, where a bus came onto a farm with folks from a church congregation, and they ran through a ditch, and it bonked, and somebody hit their head on the top of the bus. And the question is that an inherent risk of coming on the farm? We didn't get to find out. You generally never get to find out because appeals courts don't decide that. They send it back to the trial court. But the issue in those types of cases, the inquiry was, were those two signs posted? And when the two signs are not posted, there's no evidence that they were posted, then the case, the dismissal of the case might be overruled and said, no, there has to be a trial because the jury gets to decide all of this. Let me, if I can, I'd like to find, this is just a general trespass. This is just a general trespass slide, but I know I had some slides. Concept of negligence. Here we go. Because somebody gets hurt on your farm, by interacting with your operation, it's not strict liability. It doesn't mean that you're liable. Negligence is a concept, again, as I mentioned, it's evolved and developed over the course of many centuries, but it's come down to four basic requirements. And again, anybody who's injured in the environment that you provided, they have the burden of proof to show that you were negligent. And generally, negligence means that you're the agritourism operator, but you, the surgeon, you, the accountant, you, the lawyer, you, the truck driver, whoever you are in whatever environment, did not maintain the accepted levels of skill, of sobriety, of any number of things. You didn't act as a reasonable person would. And so a plaintiff coming to you to establish liability and coverage for their injury has to prove first and foremost that you have a duty. For a visitor to your farm, we have in North Carolina classified that person into two categories. Either they're an invitee with express or implied permission, or they're trespassing. You don't know they're there. For trespassers, you do not owe a duty of reasonability. If they come onto your land and they fall into an old well, it wasn't your obligation to warn them that there was an old well there. If you invited them onto your land and there's an old well and you were aware of it, and you'd failed to warn them, that could be, we don't know, but it could be seen as not acting as a reasonable person. So your duty, as someone who's inviting people onto your operation, is going to be that of a reasonable person, to not ensure their safety, but just to not have any features that are going to otherwise injure them. Allowing them into contact with animals that you were aware that have behaved erratic in the past. I would say not allowing them around sharp farm equipment, things like that. Just I even heard somebody hearing about somebody getting scratched by a rooster. Would a jury say that that was not an inherent risk? We don't know. And so, but the plaintiff also has to prove that again, you were unreasonable, you breached your duty, that breach of duty was the cause of the injury, that there was no intervening cause that caused the injury, and the plaintiff has to establish the extent of their damages, which if they are, let's see if I can move this over here and open it up. I don't know if I can. Here we go. That they have to prove the extent of their damages for a jury to um, to make an award of money. So lots and lots of things coming up in the meeting chat over here. So I'll pause there because that's just the general overview of liability. I don't want to fumble around in all my slides, but I had like a better, I think, discussion of negligence. But it's again something that has to be established. There is no strict liability that's going to hold you accountable. So I'm going to read a couple of questions if that's okay. Hunting it's an interesting category because you have this new law, or I say new, I think it was 2014, it was passed, where you can now paint the purple swatch on the tree 3 feet above the ground and has to be 2 feet wide and 6 inches, or 2 feet long, 6 inches wide.
So just to make sure everybody's following, we're looking at a question in the chat about unwanted deer hunting hounds running through property. What if those hounds cause an incident that cause either a guest injury, that causes a guest injury on the property? So this hunting dog comes up and causes an injury to a guest on the property.
Here's my answer to that. I think that for you, again, let's take the scenario. If that happens, yes, contact your insurance company. I think how that would likely shake out, that this was not something that you had control over. This was not an instrumentality, as we'd say in law, that you had any control over or anything like that. Really good, interesting question. I mean, it raises all sorts of issues, but I don't have the answer, but that's my answer to it. And so I'm going to keep moving on. I use this example all the time. So I grew up, well, I say grew up, I raised my family up in Hillsboro and spent a lot of time at Occoneechee Mountain Recreation Area. And it's accessed by a trail coming off of a road that when the weather warms, like now, and school's getting out, there's going to be cars all over the place, and high schoolers are going to be marching down that path. I think the park is now bought all the way to the road, but the rock outcropping that hangs over the Eno River is it's on Coon Rock Farm. It's on private property. And so I use that example because there's an exception to the trespasser rule, that you aren't, and again, the no duty to a trespasser, that's in our statute. Cases decided this, but then the General Assembly codified it in statute. The way I present the example is that yes, that's the law. You owe no duty of care to trespassers, except in 2 situations. One is that you do something to injure them. And it means that it's called willful or wanton, behavior. And what that means is that you did something to them. You came and you hit them with a baseball bat to get them off your property. You did something there. Wanton, I know I'm going to editorialize a little bit here. What I've always provided an example there is a very common trespass in North Carolina is ATV trespass, and we even have a statute that prohibits it, makes it a misdemeanor. That if you have an opening to your property where ATVs will ride on into the woods and ride around for a little bit, and you decide to gate that, but your gate is just a wire that you hang across there. When I see that, I think, it's again, it's a trespass, but what if someone could convince a judge and jury that should be evaluated as wanton behavior? That maybe there's a standard now that if you're going to put a barrier across an opening that people access, that you make it that people can see it, because you know what people can see and what they can't see at dusk. And I could just see that becoming, somewhat of an issue if it were allowed to go to a jury. The other exception, as an example of wanton behavior, that you sort of knew that they might get hurt, but you're like, you know what, that's on them. Maybe, it could turn around on you. The other one is what we call the attractive nuisance doctrine. And if you'll permit me, pretty sure that attractive nuisance, see, there's that, yeah, here we go. The attractive nuisance doctrine is codified in 38B-3(2), and it only applies to persons under the age of, I think the age is 14. And yeah, under the age of 14. And so, but if a child is injured on your property, say a high school student, junior high student that came to that rock outcropping and was jumping into the river, and there's an injury, and the parent brings an action against the landowner where that rock outcropping was, this is what they're going to have to prove. And it's and for all these things. But you look at these and you read them. Landowner had reason to know that children were likely to trespass. I think there are probably numerous ways to provide evidence of that there's a worn path, that you under testimony testify that, yeah, I've seen people back there. Other people testify that it's just known in the area that, yeah, it's a great place to go jump in the river. Landowner knew of unreasonable risk or serious bodily injury. That's going to be a common sense thing, maybe. Injured child did not appreciate the risk, harder to establish, but if everyone else is doing it, that might be evidence, and on and on. So you sort of see here that it's an exception to the no duty rule, but it's something that's there. And this is where we get into the area of what do you do? How do you prevent this? And that's a bigger question, because if you're going to prevent people from trespassing, again, you can't do anything there that's likely to injure them. I don't own land, and so it's unreasonable of me. I mean, I don't know, a big piece of property. It's unreasonable of me to say, hey, if you've got an opening, gate it and lock it, and put up the no trespassing signs. As it happens, the no trespassing misdemeanor in North Carolina for anybody that comes on your land, and whether they're criminally liable or criminally responsible for their act, it depends on whether they've been warned. So that's why you see no trespassing signs. Because there has to be some evidence there that they knew that they were entering onto private property and they were not welcome. If you don't have signs, this is my view, the sheriff deputy is without jurisdiction to come and grab a hold of them, because they don't know. They can certainly come and ask and order them off, but again, I think that's what creates their jurisdiction. This question here: what about people that use the river by your farm for kayaking? What could be the liability if they get out on your farm and get injured? They're trespassers. Again, you won't have liability if they're trespassers. I think even the fact that people stop at this particular place and picnic all the time, could someone establish that that's implied consent because you didn't post up signs to tell them no picnicking here, no jumping off this rock, things like that? Maybe. I don't know. That's a question that I haven't delved too far into, but to my mind, that's something that could be a possibility. But they are trespassing. They have no right. Again, if they're able to kayak, then they are on what we would call a navigable in fact waterway. The public owns the water. The landowners on either side don't own the water or the land underneath the water. But your bank is yours, and they have no right to access that bank. Um, and so what I would say is that unless they can provide evidence that you had done something um, there that might have caused the injury, um, I, again, I would argue if there was something that was pretty dangerous there, I would probably be putting up signs to issue some form of warning. I know it's not attractive. Um, I know that people might look, on the river if you care about being judged by the public and go, yeah, really, it's like, okay, fine, fine. But to my mind, I think there is some necessity of telling people that they're not to get out of their canoe and come onto your property. Now, there's there's exceptions to trespass, emergencies are one, things like that. And but that's how I would respond to that. When you're in a situation, if someone's injured and if they succeed, if they succeed in getting a plaintiff's attorney to take their case, um, a tad bit about that. Plaintiff's attorneys aren't in the business of, just writing public, injustice. They're not going to take a case against a defendant that doesn't have an insurance policy or that they can't reasonably discern that has an insurance policy. Motorists, we know you likely have one because you have to have one to have the vehicle on the road. Landowners generally are going to, all different sorts of businesses have them. But um, if a potential plaintiff is successful in getting a plaintiff's injury firm to take their case, and it's on, it's like that, it's something's coming, looks like something's gonna happen. And it's going to be important for you to have good documentation from the outset, so that when you go into that preliminary hearing, and I'm just sort of guessing how this would go, is that one of the first things that your defense counsel would do would be to file a motion to dismiss based on the statute that you owe no duty of care to trespassers. Um, and there is not a requirement, again, in that, in the law, that you post those signs to it's not the sign that creates the trespasser from a civil liability standpoint. The sign creates the trespasser from a criminal liability standpoint. But your lack of knowledge that they're there is really what makes them a trespasser. Now, but when I get to the point of implied permission, and you knew that people were getting out there and picnicking, or they might be able to provide evidence that there was no signs, I didn't see any signs. That's when it's going to be up to you to have, documentation that you had posted signs, receipts for purchasing them, pictures, things like that. I mean, I've put, I just sort of threw everything at the kitchen sink into this, and I was just making up things. And there's one thing that people do not like to hear, and that's you've got to document, you've got to keep records. But, that's, to me, that's one of the things that just goes with the territory. Because when something happens, you're not going to be able to come up with documentation if it doesn't exist already. And there isn't any sort of regulation like Fair Labor Standards Act for employment situations that's requiring you to keep records. This is a purely voluntary thing, but I think it's just a good practice whenever you take a step to lock your gate, you make repairs to a fence that's been damaged and you have livestock, warning signs, all sorts of things. It's just to have some digital record of it, some video or something like that. Again, I could go on and on. What else? What are the questions that folks have? We got 8 minutes. And I think I've covered the what I'm going to say are the basics. Just explaining what the law is. We have a number of statutes. You can read the articles that I've posted on yes, the articles that I posted on the farm law website, one of these that I'm getting at here, I'm pointing at different types of statutory exemptions for you as a landowner. Again, this is the agritourism one. It's just a couple of definitions that are in there. Um, here's the this is an exception, and you would find this in there. You're not, let's see, nothing in subsection, but this is where your case or the case against you might be able to proceed past a preliminary dismissal motion. That if this can be somewhat demonstrated, or you're called to account and provide this information. But there's an exception to your exemption from liability. Have actual knowledge or reasonably should have known of an existing dangerous condition on the land, facilities, or equipment used in the activity, propensity of a particular animal. You can see here where it's starting to add a little bit color to what might not be considered an inherent risk. So there's that. The signage, we know that's required. I've already explained that you do lose, you're going to lose that that protection. Derek, yes. Let's see here. That's me editorializing, but I believe the dimensions are in the statute. And it's not a big, huge, poster. I think it's going to be something along the lines of 11.5 or 8.5 by 11. Just again, the size of this computer screen. They don't have to be big, huge posters. They don't have to be painted in red, but they do need to have this particular language. And again, if it were me, what I would do is I would contact, and Carol, one of y'all may have this, is the Agritourism Networking Association. I believe it's still run out of NCDA and CS, our state ag department. I think they sell these signs, or I know that someone does. But that's probably the direction I would take. Liability waivers, real quick, not required by 99E. Do they work? I think they work probably about as well as 99E does. Again, it's assumption of the risk, but a liability waiver does not exempt you from negligence. If you are negligent, that's going to be an issue that supersedes any sort of any assumption that a visitor might have made. They're assuming the risk of the environment they're coming into, but they're not assuming the risk that you have failed to make safe certain dangerous aspects of that environment. And do they work? I had a slide in one of these presentations that, yeah, there are numerous cases that to where liability waivers have worked. And so it's up to you as a business. Do you want to? Great, thank you, Carol. Do you want to have your customers do that? The question here for Amy: does nonprofit status affect anything insurance-wise or liability-wise? No, not to my knowledge. Nonprofit status is merely a tax exemption or tax classification, but it does not exempt you. Now, I know I'm running out of time, but I want to point out something important here, and that is you do have several statutes in the North Carolina general statutes that do specifically address recreational activity on your land, even that which you invite, but for which you do not charge for. And so there's several. This 143B-135, trail use liability. And this is here, again, to encourage what I hope is a developing tradition in North Carolina of allowing public trail access along river corridors and other places, mountains to sea trail, things like that. This is a statute that's put there in the hope that if a rail corridor is converted to a rails to trails bike corridor, if mountains to sea trail can continue connected through land rather than along highways where landowners are denying permission, things like it's meant to, kind of help assuage the fear that liability attaches just because someone is walking through your property on a trail. Another one, and this is really to um, encourage folks to come, onto the land. Now, I'm going to use this and qualify an earlier statement that I made because I caught this earlier and I put it in red. Limitation on liability. What this is doing, it's part of a statute that says it's North Carolina public policy to make lands available to the public. As such, if you're not charging somebody to be on the land and they come onto the land, then you're generally you've invited them. You're now in that they're an invitee classification, but they're there to recreate. You've invited them on, and you're not charging them for anything. You're not selling them anything. I'm not charging them a fee. That you have a liability limitation. Again, it does not give you carte blanche to, in my view, to not to warn of dangerous conditions. That is just good risk management. The best risk management, of course, is prevention and knowing your land, knowing its history, know what's there, what might be there, abandoned mines, old wells, to falling down tobacco barns, things like that. There's also an old rusty plow, all sorts of things. It's good to know about what's where. But here I highlighted this or put it in red because it says, except as specified or recognized in this chapter, there's exceptions, of course, as owner of land who either directly or indirectly invites or permits without charge a person, educational or recreational purposes. I think this answers your question about somebody getting out of their kayak onto your bank. They're still trespassing. This doesn't mean that they've been given permission, but it might alleviate you of having to jump through a bunch of hoops to post up signs and things like that. I'm sorry that I answered and went on and on and on and wasted time addressing that question the way I did without first recalling and pulling up this particular statute. But there you have it. There is I think this statute would provide cover. Do we know if it works? We don't have any appeals court cases that tell us that. And if there has been a trial and a jury verdict of no liability, we don't know that either generally because those things don't exist in a database. They're just in court files. There's my email address. So that's my general, I'll go ahead and say this. It's the best way to contact me. I'll just leave it at that. It's the best way to contact me.
Okay.
Um,
Thank you for sharing that and your contact information. And thank you for sharing all of the body of knowledge in your head. I know that's not all of the body of knowledge in your head, but thank you for sharing what you have. That was an action-packed hour.
I didn't shut up. I kept talking.
No, it's fantastic. That's what we wanted you here for. We wanted you to just brain dump on us, and we learned so much. And thank you for addressing the questions that you did.
No problem at all. Again, check out the website, different types of questions. What I'd encourage you to do is I know I've just been up here talking and jumping around slides, but if you want to see it in a nice editorial, edited format, the extension fact sheets about these topics that I have on the website are they might illuminate better. So
both formats are fantastic, and the link has been shared. That is also an action-packed website. But we have enjoyed this time, Andrew Brannon. Thank you so much. You're getting lots of thanks in the chat.
awesome. Thanks, guys.